Hello, Demetria Graves with the Graves Law Firm, and today I want to discuss grandparents' rights and if that is such a thing. Parents ultimately can decide who their children spend time with, including grandparents, and I know that's tough. This can be an uphill battle for grandparents because there is an absolute right for parents to make that decision. So in a court case, there is what we call a rebuttable presumption in favor of the parent's decision to allow or disallow visits. That means that the law is already on the side of the parents when the grandparents might make this type of motion. This typically arises when one parent is deceased during the divorce proceedings or if the parties were never married. A high burden is placed on the grandparents, but they do have a right to go into court and ask for visitation with their grandchildren. The grandparents would have to present to the court that there was a pre-existing relationship that has created a bond, that visitation is what we call in the best interest of the children. And the court has to balance that interest of the child maintaining a relationship with the grandparents and or a visitation schedule against the right of the parents to exercise their parental authority. If the court finds that there is a more solid reason to have the custody and visitation, or more or less the visitation with the grandparents, they will allow it. In making a decision, the court can also hear the interests of the children. Typically speaking, the child must be over the age of 14. So again, it is definitely an uphill battle for grandparents, but it is not an absolute no. So if this is something really important to you, you can definitely try, but just know that the law is not on your side. Thank you so much for watching. I am Demetria Graves with the Graves Law Firm.